Having a groundbreaking idea does not automatically grant you legal ownership of it. In the creative industries, an idea alone is entirely unprotected. To cross the legal threshold into property you can actually own, that idea must be translated into a tangible, physical, or digital reality. This icon represents the idea-expression dichotomy. Copyright law exclusively protects the original material form those ideas take, like lines of code written for a software program, not the underlying concept itself. This principle applies across all mediums. A melody in your head is just a thought, but this symbol represents its translation into a fixed auditory form, like sheet music or a sound recording. Only then is it protected by law. The legal standard for this distinction was tested in the case of Donahue v. Allied Newspapers Limited. The court established that mere similarity between two competitors' products is not an infringement. Two people can have the exact same idea, but unless the specific material execution was copied, no rights have been violated. If you want to trade an idea in the business world, you must first trap it in a physical or digital medium. That is the only way the legal framework can recognize it as a transacting asset. In Australia, the primary piece of legislation governing this process is the Copyright Act 1968. Under this act, copyright exists automatically the moment a work is created. There are no formal registration requirements. However, the creation must pass two tests. The first is originality. The work must originate from the author. It cannot be a literal transcription of someone else's effort, a standard affirmed by the courts in John Fairfax & Sons Pty Ltd versus Consolidated Press Ltd. The second test is categorization. The creation must fit into specific statutory buckets defined by Part 3 of the Act. This diagram shows the primary categories for protected works. An original creation is funneled into one of four distinct buckets: literary, dramatic, musical, or artistic works. The term literary work is interpreted incredibly widely by the courts. It covers virtually anything reduced to a written or material form, including business letters, emails, databases, and computer programs. There is also a secondary funnel system under Part 4 of the Act, which protects subject matter other than works. This captures outputs like sound recordings, films, pre-recorded television programs, and broadcasts. Once a creation meets these criteria, the law instantly transforms it into what is known as a chose in action. A chose in action is an intangible piece of personal property, a right to sue or enforce ownership that exists entirely separate from the physical object itself. This chose in action is not a single monolithic shield against copying. It functions as a divisible bundle of distinct commercial levers. This node structure maps the exclusive economic rights granted under Section 31 of the Act. For a literary, dramatic, or musical work, the creator holds several specific authorities. First, they hold the right to reproduce the work in a material form, such as printing copies of a book, and the right to publish the work, making it available to the public for the first time. They also control the right to communicate the work to the public, like broadcasting it online, and the right to make an adaptation, such as turning a novel into a screenplay. For specific categories like computer programs and sound recordings, the Act provides an additional economic right to enter into commercial rental arrangements. Because these rights are property, they can be sold. A permanent legal transfer of these economic rights is called an assignment. By law, an assignment must be executed in writing and signed by the assignor. Alternatively, creators can issue licenses. A license is an authorization allowing someone else to use the copyright exclusively or non-exclusively. Unlike an assignment, a license permits use without trading away true ownership. These highly specific, severable economic levers are what allow creators and corporations to monetize innovation. They turn a static piece of art or string of code into a scalable business asset. But this creates a paradox. What happens to the human creator when a corporation buys 100% of the economic rights to their work? The Copyright Act protects the creator's personal connection to the work through a secondary, parallel set of rules called moral rights. Moral rights include the right of attribution. This is the creator's absolute right to be identified as the author of the work, and the right not to have their work falsely attributed to someone else. There is also the right of integrity of authorship. This protects the creator against any derogatory treatment, mutilation, or distortion of the work that would be prejudicial to their honor or reputation. This diagram illustrates the critical difference. Unlike economic rights, moral rights cannot be sold, assigned, or transferred. They are permanently bound to the original human creator. This legal structure results in a hidden dual ownership in almost every commercial creative asset. It lays a trap for businesses that mistakenly assume purchasing the physical asset gives them total control over it. This dual ownership structure was severely stress-tested in a 1982 dispute at the Eaton Centre, a major shopping mall in Toronto. This photograph captures artist Michael Snow's 1979 sculpture, Flight Stop, a naturalistic flock of geese suspended beneath the mall's glass roof. From a corporate perspective, the case was simple. The Eaton Centre had legally paid for the sculpture, they owned the physical fiberglass geese, and they held the right to display them to the public. The conflict began during the holiday season. The shopping center decided to unilaterally attach bright red ribbons to the necks of the geese as part of their Christmas decorations. Snow objected immediately. He argued the ribbons made his naturalistic art look ridiculous, compromising his professional standing, and he sued the Eaton Centre. The court sided with Snow and granted an injunction. They agreed the ribbons constituted derogatory treatment prejudicial to his honor as an artist, directly violating his moral right of integrity. The ruling proved a vital point. Purchasing a physical asset, or even purchasing its economic copyright, does not buy a corporation the right to disrespect or alter the original creator's vision. When someone violates the economic rules of an asset, copyright is actively enforced. For example, simply importing an unauthorized copy of a work into Australia for the purpose of selling or distributing it is a direct breach of the WARC. Owners have aggressive remedies available. They can sue for damages, seek an account of the infringer's profits, or sue for conversion or detention to physically recover the infringing copies of the material. However, this strict infringement framework has limits. To balance the scales, the law includes public interest defenses, specifically known in Australia as fair dealing. Fair dealing provides specific statutory exceptions that allow for the unauthorized use of copyrighted material. This applies if the use is strictly for research and study, criticism or review, reporting of news in the media, or for judicial proceedings. These defenses exist to prevent copyright from becoming a tool of absolute censorship. They ensure that ideas can still be debated, reported on, and analyzed, even if their specific expression is privately owned. Ultimately, this legal monopoly has a strict temporal limit. Copyright is not designed to last forever. This timeline illustrates the standard duration for works published during the author's lifetime. Protection lasts for 70 years from the end of the calendar year of the author's death. There are alternate rules for specific scenarios. If the author is unknown, protection lasts 70 years from the year of first publication. For jointly authored works, the 70-year countdown begins from the death of the last surviving author. Once that limit is reached, the bundle of rights dissolves. The material form enters the public domain, making it completely free for anyone to use, adapt, and monetize. Copyright is a temporary, highly structured legal mechanism. It is designed to balance the commercial incentivization of creators today with the eventual cultural enrichment of society tomorrow.